I was asked to speak about torture, and I'm grateful to the Humanities Festival for that request, because many people sort of think of torture as, as yesterday's problem, as Bush's issue. And I want to stress that it is still very much a current concern. Not, as you'll hear, that I think the US government is practicing torture at this moment, but rather that the issue of torture, what to do about torture, remains a very open and unresolved issue. And that's what I'd like to focus on today. Let me just begin with a few basics. I think everybody has an intuitive sense that torture is wrong. But what's not often appreciated is that it's not only illegal, it's about as legal as anything can be. And by that I mean that international human rights law establishes various rights, but many of them permit exceptions. It's written a little bit differently from the US Constitution. And so, for example, you'll have the right to free expression or the right to avoid arbitrary detention. But there are all kinds of qualifications in there. National security can trump the right to free expression in certain cases. Even things like public health or public morals can be used to limit those rights. But when it comes to torture, the prohibition is absolute. Indeed, it's absolute not only for torture, but for something I'll talk about in a moment, a parallel phenomenon known as cruel, inhuman, or degrading treatment. Which some people say is torture light, but basically is abuse that doesn't quite rise to the definition of torture, which in legal terms is the intentional infliction of severe pain or suffering, whether mental or physical. That's absolutely prohibited, but so is the lesser form of cruel, inhuman, or degrading treatment. And it is prohibited not simply in time of peace, but also in time of war. So, for example, if you look at the Geneva Conventions, you will see that they completely prohibit torture, as well as cruel, inhuman, or degrading treatment. And obviously, the Geneva Conventions are designed to deal with war. They are the laws that govern armed conflict. So this is, as absolute a prohibition as there is. Why is that? Well, many people have their own religious or moral justifications. For me, the prohibition of torture is perhaps the ultimate recognition of the humanity of the individual. It says that it is never appropriate to treat the individual purely as an instrument to get something else done. And that's usually the rationale for torture. We had a security threat. This person had information that we thought might be useful. We had to torture it out of him to make us all safer. And that kind of instrumentalization of the human being is, for me, the antithesis of what human rights are all about. It shows an ultimate disrespect for the individual that really is at the heart of the human rights movement, of human rights law. It represents, in essence, a kind of an utter loss of empathy with the individual. Suddenly, the person sitting in the torturer's chair is not a human being, but is simply a means to get something else done. And that denial of that person's humanity really is the opposite of everything that we stand for in the human rights movement. Now, you all recall that after 9/11, the Bush administration went through sort of a complicated series of explanations for why what it was doing to detainees was legal. I should stress that it never admitted that it was torturing anybody. In fact, the mantra of Bush from the outset was, "We do not torture. We treat all the detainees humanely," he said. Now, at the same time, he said the Geneva Conventions don't apply to the 9/11 detainees. And that immediately untethered his statements from any kind of legal requirement. If he had said, we would apply the Geneva Conventions, there would be a long body of law, of tradition, explaining what can and cannot be done. And indeed, the rationale there, in many respects, is one of reciprocity, because the Geneva Conventions protect not just, the enemy soldier who happens to fall into American hands, but also the American soldier who happens to fall into enemy hands. People would say, oh, well, Al-Qaeda, if you get captured by Al-Qaeda, it's curtains for you. But that's actually not what the Geneva Conventions contemplate. They contemplate, what if a U.S. soldier were captured by, say, the North Koreans or by various enemies that you could see the United States fighting, and where there is at least, a chance that they would abide by the Geneva Conventions, as every government in the world has vowed to do. But if you sort of throw the Geneva Conventions out, if you say that we're not going to be bound by them, it leaves interrogators untethered from that kind of body of law. And that is, in part how you got Abu Ghraib. You got a group of individuals who, had a vague sense that the gloves were supposed to come off, as Cofer Black, a former Bush official, said, that they're supposed to get tough with detainees, but they didn't really know what the rules were, what were the limits. And so if a little bit of toughness didn't work, they tried a little more toughness and a little more toughness, and finally you got to the point of Abu Ghraib, which was almost predictable when you're dealing with something as vast as the US military. But when it came to sort of the professional interrogators, the CIA, the problem was really much less lack of knowledge about the rules than it was the administration's decision to play with the rules. And let me, at the risk of going through a bit of history, run through what some of those legal gymnastics were that the Bush administration went through in order to justify what, in my view, was torture, although it never called it that. One of the first things they did was, at this time when Bush was saying, we don't torture, I actually went to the White House and met with Condi Rice, who at that point was National Security Advisor, and said, we notice the president is talking about torture. That's great. We're glad you're vowing not to do that. But there's this parallel prohibition of cruel, inhuman, or degrading treatment. Why isn't he talking about that? And she said, oh, don't worry, we'll take care of it. And a couple weeks later, we got a letter from the General Counsel of the Pentagon saying, we're not going to torture, and we promise to respect the prohibition of cruel, inhuman, or degrading treatment to the extent prohibited by the US Constitution. And at first we thought, great, we got what we wanted. And the qualification to the extent prohibited by the US Constitution didn't worry us so much because we remembered that when the US ratified the Convention Against Torture, it had put in a similar reservation. It said, we will adhere to this to the extent prohibited by the US Constitution. And we understood that reservation at the time because everybody was worried that some European court would say that the Torture Convention prohibited the death penalty. And no US government wanted that kind of backdoor route to prohibiting the death penalty. So they put in this reservation. It was meant to be a limit on the substantive meaning of what torture or cruel, inhuman, degrading treatment was. It turned out, though, and it took us, frankly, about a year to figure this out, that the Bush administration had something else in mind. They had in mind that because the US Constitution only applies to either US citizens, wherever they might be found, or to foreign nationals when they're in the United States, therefore, the prohibition on cruel, inhuman, or degrading treatment does not apply to non-US citizens held outside the United States, i.e. at Guantanamo or in the secret CIA detention facilities. Indeed, that is why they were so eager to keep these people outside the territorial United States. And it took us a while to figure this out, but in their view, it was okay to use cruel, inhuman, degrading treatment, at least. They still wouldn't claim torture, but cruel, inhuman, degrading treatment, so long as they did it to people outside the United States. Now, that was a radical proposition. No government in the world had ever claimed that right, but that was their view. And as I say, it took a while for us to figure this out. When we did, we went to Senator McCain, who of course was a torture victim himself, was a Republican, so an ideal person to lead an anti-torture effort, and we got him to sponsor legislation closing off that loophole, essentially saying you can't use cruel, inhuman, or degrading treatment anyplace. It passed overwhelmingly. I think it was 90-7 in the Senate. And it was a veto-proof majority. so Bush couldn't veto it. He was stuck with it. The problem is that at the same time as he signed the legislation, he asserted what he called commander-in-chief authority to ignore the law anyway. And he, in essence, and there were clever lawyers in the Justice Department who worked this out for him, claimed, I think against the law, against any reason, that he was allowed to use, theoretically, even torture, but certainly cruel and inhuman degrading treatment if he wanted to, if he felt that as commander-in-chief it was necessary. Now, of course, if you think through the logic of that argument, if Bush can do it, well, then what about Omar al-Bashir, the Sudanese president? What about Robert Mugabe, the Zimbabwean president? What about Than Shwe, since today was the pseudo-election in Burma, the Burmese leader? Basically, you can rip up the torture convention because any head of state, any place in the world can claim that they have commander-in-chief authority to use torture anyhow. So, they didn't really think this through, but this is the claim that they made. Now, to make matters worse, you all are familiar with the so-called torture memos that were written by a series of Justice Department lawyers. And what these memos did was essentially define torture out of existence. So while Bush was saying, we don't torture, the torture memos were saying that you can do anything you want virtually and it's not torture. Because they said it's not torture unless the pain is the equivalent of either death or the loss of a major bodily organ. So, chopping off ears, cutting off fingers, and who knows, none of that counts, unless it's the pain equivalent with losing your lungs or, your liver or what have you. So, again, it was something that I think upon reflection was completely unjustifiable, but this was the Bush position. And it allowed them to say that, things like waterboarding were not torture. Now, I mentioned waterboarding because this week, of course, Bush came out and said, I authorized this. So, he's almost proud of it. Waterboarding, in my view, is quintessential torture. And the reason I say that is because, if you read in the torture books, if you, kind of read about torture, the classic form of psychological torture is the mock execution. A lot of us think of torture as being on the rack or having people pulling out fingernails, but torture has not only a physical dimension, but also a psychological dimension. And what epitomizes that? Well, being lined up, firing squads before you, they're about to shoot you, and then they fire blanks or they fire over your head. And so you live through it, but that trauma is about as close you can get to torture as anything. Now, waterboarding is basically a mock execution by drowning. When you're lying there, on the waterboarding table, and they start submerging you in water or pouring water on your nose and you can't breathe, and you have no idea when they're going to stop. And as far as you know, they're going to keep going until you drown. That is the essence of a mock execution. And for that reason, I view waterboarding as clear torture. That's not how President Bush viewed it. That's not how the former CIA director, Peter Goss, viewed it, who called it a professional interrogation technique. But that, nonetheless, is the way I think it should be seen. Now, why does all of this matter? I had a meeting with Michael Hayden. I met with him when he was what's called the National Security Director, I guess. He became ultimately CIA chief. And he used this metaphor about what he felt was his duty as someone who oversaw interrogations. He said that it was his duty, kind of using a sporting metaphor, to get right up to the chalk line, to get chalk on his shoes. In other words, there is a law, and he felt that he was not doing his duty to protect America unless he pushed right up against the limits of the law, if he got chalk on his shoes. And so, these, what might seem as arcane legal matters, become very significant when you've got the guy who's overseeing interrogation, not by the freelancers at Abu Ghraib, but by the professional interrogators in the secret CIA detention facilities, saying, I want you to go to the absolute limit. And if the Bush Justice Department lawyers are telling you that the limit is, only the pain associated with death or the loss of a major bodily organ, you can go quite far. You can go to waterboarding and not worry about it. And to make matters worse, all these interrogators could wave around a Justice Department opinion so that, if in the future they face prosecution, they can say, well, what are you talking about? I thought this was legal. The highest authority within the US government has told me it was okay, which of course makes prosecution that much more difficult. Now, there were various arguments, quite apart from these legal games, that were put forth as to why torture was okay. And let me touch on a couple of them for a moment. One, and I'm sure this is something you've all heard, is the ticking bomb rationale. The way this goes is, I've got somebody here, and I think he knows where the bomb is planted on a school bus, where all these poor children are going to be blown up in half an hour. So if I just torture him now, I can save those poor school children. That's the way it's kind of put forward. And it sounds very compelling. It makes a great law school hypothetical. The problem is, life isn't like that. Because when you grab somebody, you have no idea what they know. And so you end up looking at sort of more superficial indicia. Is this person, the wrong ethnicity, the wrong religion, the wrong race, the wrong age category? Is there something in broad demographic terms that makes us think that he is a suspicious character and might know something? And of course, the ticking bomb metaphor always has the bomb ticking and about to go off. But if you believe that torture is justified to save those school children in 30 minutes, why isn't it justified to save them if the bomb's going to go off tomorrow or next week or next month? Or for that matter, why does it matter if the person you're interrogating knows where the bomb is? Isn't it enough if he knows someone who knows someone who knows someone who knows where the bomb is, and by torturing down that chain of knowledge, you can save those school children? You can see how it's a very elastic rationale. And indeed, it's not elastic just, hypothetically speaking. We actually have experience with a country that has based its interrogation regime on a ticking bomb rationale. That country is Israel. There was a time in 1987 when Israel had something called the Landau Commission, which reviewed Israeli interrogation policy and authorized not torture, they authorized what they called moderate physical pressure in a ticking bomb situation. And so this was the guiding philosophy of Israeli interrogators for 12 years. And what we found from that period from 1987 until 1999 is that very quickly the interrogators stopped worrying about whether the person being interrogated himself knew where the ticking bomb was. It was sufficient that this kind of chain of knowledge was there. And so by the end, between 80 and 90% of male Palestinian security detainees were being severely mistreated. Many would argue torture, including very severe shaking that killed some people and the like. Until finally the Israeli Supreme Court stepped in and said, we cannot base our interrogation policies on something as elastic and vague as the ticking bomb rationale, and they ended it. And so today, I won't say the torture has disappeared in Israel, but it's much less of a problem than it was a little over a decade ago. Now, another proponent of using torture by the US was a Harvard law professor, Alan Dershowitz. He's a famous guy, many of you probably have heard of him. And he had this brilliant idea that the way to deal with torture was to ask the administration to go to a court, to go to a judge, and have him issue a torture warrant. And then when you had your torture warrant, the same way you'd have a search warrant or an arrest warrant, then you could go torture. And he thought that this was a good idea because he thought it would be a way of limiting torture. His view was torture happens all the time anyhow, and this will be a way of bringing it, out from the closet and into the spotlight. And by doing so, we'll limit it. It had a certain internal logic to it until you start thinking through what this really meant, because suddenly it meant that torture was going to be legitimized. It went from being something that is always prohibited in every circumstance to something that's sometimes allowed. So you lose this ability to absolutely stigmatize this series of techniques. Indeed, you can almost imagine that given the possibility that a judge will authorize torture, that you need, various law enforcement departments to create torture squads so that, if the warrant comes, they'll know how to do it. And then these torture squads will become kind of internal advocates for using this technique. And it'll sort of generate a bureaucratic momentum toward torture. It also, I should say, Dershowitz's proposal had excessive faith in the ability of judges to say no when this would not be an adversarial proceeding, because presumably the request for a torture warrant would happen during the investigation. And investigations, are the quiet phase. You don't tell a defendant that he's being investigated. And so you basically envision, the government going to a judge ex parte without any defense lawyer present, presenting secret evidence and saying, we think this secret evidence justifies a torture warrant. We know how judges behave when presented with a similar procedure to get a wiretap. They almost always say yes, in like 99% of the time. When the government comes in ex parte on the basis of secret evidence and asks for a wiretap, the judge says yes. That's called the FISA courts are the ones who do this, the Foreign Intelligence Surveillance Act. While I would imagine judges would be a little more reluctant to grant a torture warrant, the experience with the FISA courts does not leave me confident that judges would stand up and treat torture as a rare option. So this idea of torture warrants, while perhaps well-intentioned, while perhaps designed to minimize torture, I fear would legitimize torture and would make it just part of the routine arsenal available to our law enforcement agents, rather than a practice that should never be resorted to. So this was, those were kind of two of the efforts to deal with the Bush administration's torture, the ticking bomb scenario and this idea of torture warrants, where rather than just saying it was wrong per se, it was an effort to say, okay, we're going to do a little bit of this, but let's try to contain it. Now, as I said at the beginning, my view is that torture is wrong as a matter of basic morality, not to mention of law. But what I found during the last 10 years in speaking to government officials is that it's often, in fact, it almost never is enough to leave it at that. If you go into a government official and say, torture is wrong, don't do it, sometimes they'll agree with you, but if they are not, basically persuaded before you walked in, they won't. And what I found that I had to do in speaking to government officials is make a series of pragmatic arguments. Arguments of principle didn't carry the day. And so I had to talk about, what is the consequence of a policy of torture, or for that matter, of cruel, inhuman, and degrading treatment? One consequence is, of course, it undermines the prohibition in and of itself. Because the United States is not just, an ordinary country. If Robert Mugabe in Zimbabwe is torturing, people say, well, he's violating the law. But the law is still there, and we all know that what he's doing is wrong. But if the US government tortures despite the law, the effect is to undermine the law. It lowers the standard, it lowers the bar for everybody. I had a personal encounter with this. I was meeting in Egypt with the prime minister at the time, still the prime minister, Ahmed Nazif. And it was at a moment when we knew the Egyptian security forces had just picked up a series of suspects in the Sinai and were torturing them. And so I said this to Nazif, and I pushed him to stop. And without skipping a beat, he said, but that's what Bush does. Now, and I knew then, that was a cheap response. That didn't justify it. But it was a politically effective response, because while this was taking place within the privacy of his office, you can imagine, how this would play out on Al Jazeera TV or in the press. Human Rights Watch condemns Egypt for torture, and Nazif says, who are they to talk about us? Bush does the exact same thing. And in the realm of public opinion, that argument, for many people in Egypt would carry the day. And so what the US does has a very direct consequence on how the rest of the world operates. But for me, the biggest problem with the resort to torture is that I don't think it makes us safer. The rationale for resorting to torture after 9/11 was that the United States faced a very severe security threat, and it needed extraordinary measures to protect us Americans. And so, in the end, the only way we were going to convince anybody in the government to dispense with torture was to convince them that that fundamental rationale for torture was wrong. So let me unpack how I look at that. Clearly, when you're tortured, almost everybody in the end will say something. It's extraordinarily difficult to resist torture indefinitely. And so, people under torture start to talk in the end. Whether they say something that's accurate or inaccurate is a whole different matter. They usually tell the torturer what they think the torturer wants to hear in order to stop the torture. That's the paramount goal. That may or may not be accurate. But I think we have to accept that people who are tortured talk. The question is that incremental advantage of sometimes getting truthful information out of torture sufficient to justify what, in my view, are ways in which torture undermines our security? And I say this in three senses. In my view, the purpose of law enforcement is to prevent crimes, to deter people from resorting to crime, and to punish people who have engaged in crime. And if you look at those three elements, prevention, deterrence, punishment, I think a case can be made that torture makes things worse in each case, not better. Let me explain what I mean. First of all, when it comes to prevention, we've seen over and over that the handful of cases in which terrorist attempts are stopped before they come to fruition almost always involve somebody who has knowledge of the proposed terrorist act telling law enforcement officials. It basically requires an insider to go to the police, to go to the intelligence agency and say, such and such is up, you should pay attention to it. Sometimes it's actually family members, other times it's friends or neighbors, but the tip from a cooperating witness is the most important tool for fighting terrorism, far more important than anything that could ever happen in the interrogation room. But when you look at the consequence of torture, people are less likely to go to law enforcement agents if they feel that in doing so, they are becoming complicit in nefarious practices like torture. If you think about it, it's one thing to go when the law enforcement agents have the moral high ground. But if they are stooping to torture, many people will be reluctant to take part. They certainly don't want their neighbor to be tortured. They don't want themselves to become complicit in that kind of dirty enterprise. And while I don't claim that this is universal, some people will go to the law enforcement people nonetheless, the fact remains that many people will be reluctant. And so by losing the moral high ground, by engaging in these practices such as torture, law enforcement agents discourage the kind of popular cooperation, which, when you talk to the experts, they'll tell you is the most important tool for preventing torture. Second is the issue of deterrence. Obviously, people are deterred to some extent by the prospect of being caught and punished. But the motivations that go into a willingness to commit a terrorist act are complicated. There's been a scholar at the University of Chicago, Roger Pape, who's talked about the importance of occupation as a motivating factor toward terrorism. One thing that's become clear to us as we've looked at sort of terrorist websites is that the terrorist recruiters love Guantanamo. They love Abu Ghraib. They love the secret CIA detention facilities. They love the tools and practices of torture because that, as you would imagine, gets people riled up. They get angry. They get mad on behalf of their compatriots who have been subjected to this kind of inhumanity and indignity. And so, while of course not everybody, in fact, the vast majority of people may be upset, but they'll just go on to their day-to-day lives, some small percentage of people will be so outraged by the use of torture that they themselves will vow revenge. And of course, when you're talking about the millions of people in the world who will know about the torture, even if a tiny little percentage of people are motivated to move on and become torturers, you can imagine, what a huge problem that creates. Let's say it's hundreds or thousands of people. Nonetheless, these are people motivated to move forward and commit a terrorist act. And so I think a strong case can be made that, whatever torture plots are uncovered through torture, you have a much bigger problem of generating torture plots through the use of torture. And finally, when it comes to the issue of punishment, torture makes punishment virtually impossible. One reason why the military commissions in Guantanamo have been utterly unsuccessful is because so much of the evidence collected has been the product of torture. So many of the defendants have been put through torture. And under the US Constitution, quite properly, not only can you never use a defendant's coerced statement against him, you also can't use any leads drawn from that statement to pursue the prosecution against that defendant. And given that constitutional requirement, it's been very difficult for the prosecutors, whether at Guantanamo or even in the civilian court system, to pursue cases once somebody has been tortured. Now, where does this leave us today? I opened by saying that while I don't think the US government today is torturing, torture is still a very much unresolved issue in this country. President Obama has talked about looking forward, not back. And by that he means, that he has ordered an end to torture and an end to cruel, inhuman, degrading treatment. He's not using the Bush loophole. He's prohibited this kind of treatment any place in the world. He shut down the secret CIA detention facilities where a lot of the torture took place. And so if you say, what is the US government doing today? As far as we know, it's respecting the rules with respect to torture and inhumane treatment. The problem is that in saying he doesn't want to look back, he has shut the door on prosecuting the crime of torture, and it is a crime, I should stress, under US law and under international law when people engage in torture or cruel, inhuman, or degrading treatment. Indeed, he's not only blocked prosecutions, but he has even blocked civil suits by claiming that if you sue the people who were responsible for the torture in court, that would reveal state secrets, and therefore the civil case cannot proceed. He's refused to allow any kind of truth commission to be established that would even get at the, kind of create a definitive record as to what happened. Now, I think Obama's aims in all of this was to reduce partisan rancor, to move on. He clearly had a big legislative agenda before him, not an easy one by any means. I can't say that he avoided partisan rancor. There's clearly been plenty of that. And in any event, in my view, something like torture should not be subject to partisan calculations. The duty to not only avoid torture, but also to prosecute those who have committed acts of torture, in my view, is an absolute. It isn't something that should vary with the political winds. The reason I say this is the president in many ways can be understood as the chief law enforcement officer of the United States. He has a duty not simply to respect the law, but to see that the law is enforced. Imagine, a sheriff who says, I'm going to make sure that, from now on, everybody abides lawfully, but we're going to forgive all the crimes that happened up until now. That would generate outrage. People would say, well, you're creating a precedent of impunity. You're encouraging more crime. That, in essence, is what the president has done, not in some minor area, but in an area, which represents one of the gravest crimes around. It's not a mere peccadillo. It's not a mere error of political judgment. These were deliberate decisions taken to engage in practices that the entire world has said should never be used. This sets a very dangerous precedent, not only for the rest of the world who say, well, if US officials can get away with doing this, why should we prosecute our own torturers when they were convenient at the moment? But it also sets a precedent in this country, which worries me. Because I personally don't think Obama is going to resort to torture. I have enough faith in the man that I think that, for the duration of his presidency, the US government will refrain from these sorts of practices. But there'll be a next president and a president after that. And if there is a precedent that you can get away with this, that, this is a tool that you can resort to, and then we'll just leave you alone. We'll treat this as an unfortunate moment, but no one will get prosecuted. No one will be held to account. There won't even be official exposure of what you've done. It's going to encourage some future president, and maybe not even that far into the future, to resort to these practices again, to resume the use of torture. So, where does that leave us now? Ideally, we would reverse Obama on this. We would get him to look backwards, not just forward. But I don't have a lot of faith in that being a possibility. With the new Congress coming in, I don't foresee greater opportunities there than we've had to date. And to date, they've not been willing to stand up and really push the administration to deal with the torture of the past. So I'm afraid that what that leaves us is various efforts to delegitimize what happened. And I don't want to diminish this because even if people are not prosecuted, even if they're not held officially to account, if we can make clear as the American people that certain things do not represent us, this is not what America stands for, we can help to build at least a popular norm that will make it more difficult for some future government to resort to these practices. So I think forums like today's are very important because it helps people understand what's at stake and to try to find ways to stand up and say, this kind of practice doesn't represent me. This is not what I think our government should ever do. I would like to see opportunities, frankly, to discipline some of the lawyers who authorize these practices, people like John Yoo or David Addington, Cheney's lawyer. The bar associations have so far been reluctant to do that, but I think they could still be pushed in that direction. I think we should continue trying civil suits, even though the Obama administration's tried to block them with the state secrets privilege. We should still push those forward, and there may come a time when a judge rejects the state secret privilege and allows the case to go forward. There is the option still of foreign prosecutions. Torture is a crime of what's known as universal jurisdiction, meaning that a torturer can be prosecuted any place in the world. And I don't anticipate that Cheney or Rumsfeld or Tenet is going to be traveling any place outside the United States anytime soon. But should they, particularly if they go to Europe, I wouldn't be at all surprised that an effort is made to prosecute them there. And finally, I think it's important that whenever people who were involved in the torture appear and speak publicly, that there be efforts to protest them, that there be efforts to make clear that what they did is not what we think is the appropriate thing for any government official to do. The aim of all this would be, it's second best to prosecution, I admit, but the aim would be to do something like what occurred with the Japanese internment camps, which during World War II were seen as necessary, and the people who behind them were never prosecuted. But nonetheless, today, the use of the internment camps is widely seen as having been, a huge error, something driven by fear, but nonetheless something that was wrong. It reflected a lack of appreciation of the fact that these Japanese Americans were, after all, Americans. They had rights just like everyone else. And to just detain them without any justification beyond their ethnicity was wrong. It was overbroad. It was an inappropriate response to a security threat. I hope that the use of torture similarly is seen as an unnecessary, unhelpful, and wrong response to security threat. An ugly chapter in American history that will never be repeated. We can't count on this administration to send that message, but I think if we generate enough pressure, if we find different ways to make that point, we, as the American public, can gradually help build an understanding so that the use of torture will be seen the same way as the Japanese internment, something that no government should ever resort to, even in time of a serious security threat. So let me stop there, and I would welcome your questions or comments. I guess we have a microphone here, so yes, go ahead.
You say that the present administration is following the rules, but what I'd like to ask you is internationally, outside the Constitution and outside the Geneva Convention, what laws that the U.S. has subjected itself to make torture illegal? And with respect to the Geneva Convention, I've heard an argument from time to time that if you have an agent or a citizen of a recognized government, that the Geneva Convention applies to it, but otherwise not. Could you respond to that?
Yes. There basically are three treaties that prohibit not only torture, but also cruel, inhuman, and degrading treatment. One is what I alluded to already, that it's called the Convention Against Torture and Cruel, Inhuman, or Degrading Treatment. And it's a treaty that everybody has ratified, including the U.S. The second is, in a sense, the leading treaty in this area. It's called the International Covenant on Civil and Political Rights, which has a provision on torture and inhumane treatment. And again, everyone, including the U.S., has ratified. And then the third is, of course, the Geneva Conventions. Now, the Geneva Conventions, most of the Geneva Conventions have to do with what you might call intergovernmental wars, where things like a prisoner of war only applies if you have a formal government, a formal army on both sides. But there is a section of the Geneva Conventions, it's called Common Article 3 of all 4 Geneva Conventions, which have to do with war against non-governmental actors. And in that Common Article 3 is a prohibition on torture or inhumane treatment, which does not depend on the victim being a soldier in an official or a governmental army. And the Bush administration should have recognized that, as well as the relevance of the other 2 treaties. They just never talked about the other treaties. And with the Geneva Conventions, they sort of dismissed them by saying they were quaint. And parts of them probably are quaint. Some of the bits about some of the details about how you treat prisoners of war. But the core prohibition on torture and inhumane treatment is far from quaint.
You said that you made some pragmatic arguments against torture to government officials. Wouldn't one of the conceivable arguments, be the psychological damage caused to the torturers themselves? I mean, in 15 or 20 years, won't they be making claims on the government that will be costly?
Yeah, I mean, that's a good. I mean, I didn't make that argument, although it's a good one, because I'm sure that the people who engaged in torture, many of them are going to be very disturbed by it. One psychological argument that the government made as to why waterboarding wasn't so bad, it kind of reversed your argument a little bit. There's something called SERE, S-E-R-E, I think it means survival, evasion, resistance, and escape. And it's the training that special forces are given so that they can resist interrogation by enemy forces, including possibly torture. And part of this SERE training sometimes involves something that looks a little bit like waterboarding. And the Bush administration said, if we do this to our own soldiers, of course we can do it to the enemy. The difference is that if you're kind of a U.S. soldier there, having another U.S. soldier pour water on you, you're not going to be killed. They're doing this for a period of time, and then they're going to stop. It's unpleasant, but it's not a mock execution. You never really think your life is in danger. It's completely different if you're some terrorist suspect, and their enemy is pouring water on you, and you have no idea when it's going to stop. And so that cheap argument, that analogy to the SERE training, completely missed the mock execution element that in my view makes the waterboarding torture.
Could you please comment on the practice called extraordinary rendition, where we send people to other countries to be tortured? And I wonder if we're continuing to do that.
Yeah, no, that's a good question. Extraordinary rendition, I mean, the way it's become understood, had to do with taking terrorism suspects whom, for whatever reason, were not big enough fish for the U.S. to interrogate itself. But they wanted to see what they knew. And so they would send them off to places like Syria or Egypt or Morocco, knowing that the interrogators there were going to torture them. Now, the Torture Convention prohibits not only torture when you do it yourself, it also prohibits sending anybody to a place where torture is reasonably predictable. So that kind of extraordinary rendition was also a direct violation of the Torture Convention. Now, the way the administration got around it is they said, well, we got the Syrians to promise not to torture. There's this thing called diplomatic assurances. Some nice Syrian diplomat came in and said, we'll treat him nicely. Now, you can imagine the problem with that. I mean, Syria ratified the Torture Convention too. It's legally bound not to torture, and it tortures all the time. So if they're ignoring the law, why are they going to suddenly respect the word of a mere diplomat? Plus it's utterly meaningless, because if you can imagine, the State Department would say, oh, well, we'll go visit the person in custody and make sure he's being treated properly. Imagine yourself, you're the torture victim, and some nice U.S. diplomat shows up and says, how you doing? Now, you've got this awful choice at that stage. Do you admit that you were tortured, knowing that you're going to be put right back in the torture chamber? Or do you just pretend everything's okay? It's just impossible to reliably monitor the way a single prisoner is treated in custody. And so I don't think the Obama administration today is actively sending people to places like Egypt, but they are maintaining this fiction that they could with diplomatic assurances. And in our view, that is, it's a cheap excuse for violating the convention. It's not a realistic remedy to avoid somebody being tortured. And so if a country systematically tortures a certain type of suspects, say security suspects, no one should be sent there, period. That's the rule we believe should be followed.
I'm sure with the previous administration you made the argument with relation to what happens with American soldiers when they're captured by the enemy in terms of torture and cruel and inhuman pleasure. What was their response to that?
They didn't really want to engage on that kind of government-to-government level. I mean, they like to think of this issue as only one of Al-Qaeda. And obviously, if you're captured by Al-Qaeda, it's not good for you, And it's there's no way that Al-Qaeda's treatment of a detainee is going to be guided in any sense by what the U.S. does. They're going to mistreat you, period. They wouldn't bring the conversation past that point. They wouldn't recognize that there is a precedent being set here that is going to endanger American soldiers. Now, when I say they, I should say the civilian leadership of the Bush administration. The uniformed leaders completely got this. And indeed, some of our best allies during these debates were generals who completely understood the significance of ripping up the Geneva Conventions and how that would endanger American troops. And they hated this policy, but they were repeatedly overruled by their civilian superiors.
You mentioned the U.S. internment of Japanese citizens in the United States. And we know, I remember reading that they did get some dollar compensation. Mm-hmm. But did the procedures that led up to that establish any precedent for maybe 2 generations from now to go after these people that you're saying even the Obama administration doesn't want to go after because it would set a bad precedent for going after people who did allow the torturing now? Did that payment establish anything that they can use in the future?
Well, I should say that there's no need for sort of any exceptional remedy to go after the torturers. I mean, it is a requirement of U.S. law that if you torture, you be prosecuted. Just in the federal code, it is a crime to torture. So they don't need to go. I mean, I use the Japanese internment example as something where, despite the lack of prosecutions, nonetheless, we all understand it as wrong today. That may be the most that we can hope for with torture. But, Obama tomorrow could say, I've had a breakthrough here and I've decided we're going to go after the Bush torturers, and he could do it like that. He doesn't need Congress's approval. The fact that, they've lost the House doesn't mean anything. This is just a matter between Obama and Eric Holder, the Attorney General. And the only thing holding up these prosecutions is Obama's refusal to let them go forward.
I'm just feeling concerned about the fact that torture and punishment seem to be within the same logic of thinking that one person that has committed one crime is kind of the cause of the problem. And I just see it as kind of like mushrooms. You just see the mushrooms and you think, oh, here's the problem, where actually the underlying cause is all that network that lies inside the surface. And so I'm aware of just to what extent the law can actually create profound social change as to stop torture, because maybe you might be able to pass a law that says, okay, so now we prohibit torture, or you get people in power to agree they won't torture, but the main causes of what the psychological disturbances cause is still there.
Yeah.
So what are the venues of profound social, psychological, spiritual change to stop torture do you envision?
Yeah. No, I mean, you make a good point in that, as I said, we don't need a new law outlawing torture. It's already illegal. Nonetheless, Bush felt comfortable enough not only to order it, but to admit that he ordered it. And why is that? Well, because enough Americans thought it was the right thing to do. And so the only way, ultimately to ensure that we don't have another episode of torture down the road, that we actually do have a government that respects the law, is to build up, a public sense of morality that was the wrong thing to do. And in the end, the law, as we've seen, it's not enough to have a good law. You have to have broad sentiment within the public that that's a law that deserves to be respected. And for at least a few years after 9/11, when many Americans were very fearful, we didn't have that popular sentiment. And the Bush administration exploited it and actually used torture. So you're right that we have to focus not just on the law, not just on governmental practice, but on popular sentiments behind that.
You've mentioned the legal reasons and moral reasons and pragmatic reasons against torture, all of which I agree with. But obviously within the administration, there is another side to this debate. Somebody must have thought it works. Mm-hmm. Did it?
Well, did it work? I don't think it did. If you look at their best case scenarios, people like Khalid Sheikh Mohammed, I forget how many times he was waterboarded, 150 some, and even though Cheney, for example, was running around for a while saying, they told us all these plots that were forthcoming and we got all this great information from them, no one has ever come forth with anything specific, and indeed, many people with knowledge said they got nothing out of this. And so the proponents of torture have yet to put forward any convincing case that it helped us. And there are lots of reasons to believe it hurt us.
I want to go back to two things that you mentioned. One is extraordinary renditions. It is well documented now that this practice started, that the US started sending people back to Egypt and the likes as back as in the mid-1990s, and the program was established under former President Bill Clinton. But yet clearly this is not very well known, and the practice and the policy and the program is more associated with the previous administration, with Bush. Why is it not well known that it was actually Bill Clinton who started the program, and have any efforts been made to establish the truth about this and possibly prosecute if there is legal clarity? And the second thing is waterboarding. Is there now more legal clarity about where it stands under US law? I'm asking, of course, because as you mentioned, Bush now admitted this week publicly that he authorized it, and there doesn't seem to have raised the chances that he is going to be prosecuted for violating a crime.
Okay, well, first, on the extraordinary rendition point, there is the problem is that the term extraordinary rendition has meant different things at different times. Bill Clinton did have a policy of extraordinary rendition. And at that point, what that meant was that he would basically extradite people to be tried without going through formal extradition treaties. They would just send somebody off, and the Egyptians or whomever would pick them up and try them. As used by the Clinton administration, the purpose of the rendition was not the interrogation. The purpose was prosecution. Under Bush, that changed. Under Bush, the purpose, they didn't actually care about the prosecution. They just wanted the interrogation. And so while a similar term has been used for both policies, the policies were actually very different. Now, in terms of waterboarding, I should say that the US in the past has prosecuted people for waterboarding. And so, this is not just, my interpretation of it as a crime. There actually have been courts-martial for waterboarding. But now that, the fact that Bush has admitted to ordering it is going to lead to prosecution only if Obama changes his mind, or if some future president changes his mind. But the fact that it's a crime and that Bush has admitted to it doesn't mean he gets prosecuted unless the Attorney General and therefore Obama decides to do it. And so far they've refused to do that.
Ladies and gentlemen, we only have time for one more question.
Could you speak to the extent to which violations of the Convention Against Torture have been prosecuted internationally, and what position the United States has taken on those cases that occurred elsewhere?
Yeah, I mean, for the most part, the U.S. is a proponent of prosecuting torture. If you read the State Department's annual human rights report, they condemn torture, they push for prosecution. The Pinochet case in London, even though Pinochet committed disappearances and summary executions, what he was prosecuted for was torture, because torture happens to be a crime of universal jurisdiction, and so the Spanish judge could indict him for that, and the UK courts could arrest him for that. So it is, it's kind of very fundamental, broadly agreed that torture is a crime and that it should be prosecuted. It's just that first the Bush administration and now unfortunately also the Obama administration has been unwilling to apply that firm standard to our own conduct here in the United States.